started. Good afternoon, everyone, and thank you for joining us for Parles Reckham's Lunch and Learn series. I'm Lisa Parles. I'm a partner in Parles Reckham, which is a New Jersey law firm that represents individuals with disabilities and their families. Just a couple of housekeeping things. This webinar is being recorded. We would ask everyone to please remain on mute. We're going to have time at the end for questions, so you can post your questions in the chat, and you can do that as the webinar is going on. You don't have to wait till the question period to do that. So if you think about something during the presentation, go ahead and put that in the question mark. We're going to talk about estate planning today, but I know it often leads to some more questions regarding DDD eligibility or that adult process. So I just want to let everyone know we do have a recorded webinar on the Parles Reckham website, and it's accessing adult services. So that can be very helpful too if people want more information on that. So as I said, today's topic is essential estate planning documents, and it's my pleasure to introduce Harold Grugberg, who's of counsel to Parles Reckham. Harold's a certified elder law attorney and has extensive experience in a number of areas, but particularly estate planning and probate law. He's been, based on peer reviews, designated a super lawyer since 2011. In addition to offering expert advice, Harold approaches each case with competence, but most importantly, and why we just love having Harold with us, is the care and compassion that he approaches each case with. So before I hand it over to Harold, I just have a couple things that I'd like to cover in the way of background for keeping people eligibility, or even if you're not in a situation where your loved one is going to need to maintain DDD or Medicaid eligibility, these are still important things to think about. So we're thinking about the post-21 world. I also do want to just let everybody know that I will unfortunately have to leave the webinar shortly, but you're in great hands with Harold. So Karina, can we have next slide, please? Okay, so I believe it was John F. Kennedy that said this in one of his speeches: the time to fix the roof is when the sun is shining, which is good advice, which is why we run these all the time. So people have at different points in their life that they can stop and think about these future planning. But obviously, when you're the parent of a loved one with disabilities, it's often hard to find that time. And sometimes we do recognize that it is pouring, so it's hard to stop and do that. But I'm going to walk you through some just key areas to think about. And we're going to end, obviously, looking at the importance of trust and estate planning. So the first point I want to make is about transition assessments and goals. So if your loved one has an IEP, at 16, they must, under law, have a transition plan with specific goals in their IEP. They're supposed to start thinking about the plan and talking about the plan at 14, but by 16, the goals have to be identified. This is an area we often see lacking in IEPs, that it is, just boilerplate language. Sometimes it's literally the goal is that they'll connect you with DDD, and they're not really breaking it down to more important goals, skill-based goals. So that's where we make the point about thinking about getting some assessments done, particularly between 14 and 16, because assessments not only tell you where you are, but it helps identify goals. And at that time, we also want to be thinking about what are some of the lifelong goals that we want to be addressed. So that is something you can ask for in specifically a transition assessment. Next area that comes up is guardianship. We can file 60 days before the 18th birthday. It's a little bit of a gap in the law because you can't file before. So when the process starts, when the person turns 18, we are going through the procedure because in New Jersey at 18, if you don't go to court and take action, the person is deemed an independent adult and can make decisions, including signing himself out of school or leaving a program. So it's something we'd like to take a look at well before the 18th birthday, but we do file around 60 days before. Lots of options in New Jersey. We have full guardianships. We offer limited guardianships that can carve out areas. If it's determined, which our office will work with you, that a guardianship's not appropriate, another option could possibly be a power of attorney, giving parents some access to in decision making. That's something that we do turn to Harold to when we determine that guardianship is not appropriate. But I will tell you, we do have a lot of options in New Jersey, and the court does let us, with the help of a court-appointed attorney, carve out areas if a full guardianship is not appropriate. Something else that comes up is that at 18 you can apply for Medicaid, obviously provided that you're eligible, which Harold is going to address that, why we need to do appropriate estate planning. Why that is important is because in New Jersey, that's how we fund adult services. It's a federal state matching program. Literally on the first page of the DDD application is what's your Medicaid number. So most people will get Medicaid through their SSI application, but there's a couple other routes as well. But you can apply at 18. Now, again, important, critical for DDD. You can apply DDD as young as 18, but services don't start till 21. So we usually don't apply right at 18. We like to get the transition assessments done, guardianship in place, applying for Medicaid and SSI, but wait a little bit closer to graduation because they often will make you redo the assessments if it's done, several years back. And also, I also find that people's circumstance change. So we may have a situation where we are not just asking for the day program supports program budget, but we're asking for a larger community care program or a residential. And that's going to be really important for that to be around the time of determination. So we usually say, let's start talking about it at 20. And then the last thing that's sort of on the getting ready for post-educational life is the trust and estates planning. Now, people ask all the time, when should I do that? And we really do think it is ASP, as soon as possible. Whether or not your child is going to need the lifelong Medicaid eligibility for DDD services, all parents, all individuals with or without children should really look at their trust and estates plan, because you want to have some key documents that Harold is going to talk about, just a general will or a power of attorney or healthcare proxies, those type of documents. But as Harold is going to talk about in more detail, if you have a child with special needs, then there's a real danger if you don't have those documents in place, because it can knock them out of that Medicaid eligibility, which then they can lose their DDD funding, and it's a very difficult thing to unwind. So these are all areas that are getting us ready for the post 21 years, which are more years than pre 21, and there's just not as many resources to get families ready for adult services. So with that, I'm gonna ask Karina to advance the slide and turn it over to Harold. And thank you all again for joining us. And we, of course, have a number of resources on the website, and we do repeat our webinars as well. So if you're on here today, you of course will get more notifications of future webinars. Harold, the floor or platform or Zoom, whatever we call it these days, is yours.
Thanks a lot, Lisa. And, I really appreciate that Parles and Reckams puts this together and allows us to, pass on this information to people who are interested. I do have my chat open. I will be answering any questions that you have in the chat at the end. So let's start with the most important topic today, which are special needs trusts. And why are they so significant? The roadmap of services and benefit plans for children with developmental disabilities is incredibly confusing. The New York subway system map makes it seem is easier than the roadmap for the variety of different programs that are available. The one thing we know to get in the door of both SSI and Medicaid is that a person applying for these benefits has to have assets less than $2,000. And that person has to maintain their assets below $2,000 to keep that Medicaid eligibility. And without that Medicaid eligibility, there isn't DDD eligibility. Now, I'm sure we'll have another seminar on some modifications that have occurred to DDD rules. And the one that Lisa made reference to accessing the services through DDD that's already online is really helpful. But the purpose of the SNT is to ensure that your child maintains their eligibility for SSI and Medicaid, which once again gets you in the DDD door. We're going to talk a lot about special needs trusts at the end of today's seminar. But the one thing I want to hit upon now is something that a lot of people consider and oftentimes are advised by attorneys. And the notion is don't leave money to an SNT in your will or otherwise, because it creates this huge administrative responsibility of managing the trust. Instead, leave it to somebody else, leave it to a sibling. And that way, none of the administrative responsibilities are there, none of the requirements to maintain eligibility are there, and that child can use the money for whatever they want. And you know, on the outset, that seems good, right? Why not have flexibility and less hassle and less time with lawyers? And, you know, I'm a lawyer and I don't want to spend time with lawyers. But the problem is, if you leave money to a child or a relative with the understanding that they'll use it for your developmentally disabled child, there's multiple probabilities that that money won't be there for them. And when we do that, we also have to look at two sides of the coin. So if I leave money to my son to care for our daughter, and my son is married and gets divorced, the money is gone. If my son dies and leaves the money to his spouse, she may not use it for his sister. More importantly, that money is going to be theirs for a lot of purposes that people don't intend. For instance, student loans. So, you know, my kids are doing their FAFSA. I'm holding my sister's money. No one in the world knows that's my sister's money. And it could be, it will be available to consider student loans for my children. And the other thing is, if I have some sort of a creditor, you know, I rear end someone and my policy doesn't cover. Under all those circumstances, the money that my parents wanted me to use for our sister, for my sister, may not be there. So probably if you're balancing the administrative requirements of special needs trust, which we're going to talk about, against the goal of making sure there's money there for your child, you really have to balance and weigh heavily in favor of going through the administrative hassle of having a special needs trust as compared to that money not being there at all. Let's change this. Let's move the next slide. So we're talking today about pitfalls in basic estate planning documents. And a lot of these pitfalls you may have today, hopefully not. And we're going to go through these things in detail, so you can go and open up that file that you have, or your fireproof box, and look through your documents. The first thing is power of attorney. Now, why is power of attorney so important? Well, when you think of what you do from the minute you wake up to the minute you go to bed, every decision you make, where you're going to live, what you're going to eat, who your doctors are, these are the type of powers that are incorporated into a power of attorney. So, you know, we're not talking about something that happens after your death. We're talking about something while you're alive. And that's why powers of attorney, from a legal standpoint in my world, are the most important document you can make. So let's go to the next slide. So what is a power of attorney? A power of attorney is a contract that you make with another person. It's a contract that's revocable, that can end. You could rip it up at any time. And it's a contract that details powers you're giving that person to make if you do not want to make those decisions yourself. The people in a power of attorney are primarily two. There's the principal. If you're making the power of attorney, you are the principal. And then there's the agent. The agent is the person or persons you name to be decision makers for you. You can have multiple agents. You can require your agents to do everything together, or you can allow them to act individually. Probably the first pitfall that people make in powers of attorney are not having successor agents. Now, why is this so important? Typically, when you name an agent, you name the person who's the closest to you, who is going to give you the help that you're going to need one day. Um, and if you run out of those people, then your power of attorney cannot is now no longer valid. You don't have anybody to make those decisions for you. If you have capacity at that point, you can make a new power of attorney, you can name another person. If you don't, though, then we talk about guardianship. And guardianship is a court proceeding that's very expensive, probably anywhere between $5,000 and $10,000. But here's the most important thing about guardianship. In a power of attorney, you can name the people who want you to make decisions for you. Under guardianship, we have a law in New Jersey, and the law says these are the people who can be your guardians in this order. And the order typically is your spouse, your children, your siblings, your nieces and nephews, your grandchildren, and then the Office of Guardianship Services in New Jersey. Now, you may not want those people in that order to be your guardian. You may say, you know what? I really want my sister to be my guardian, not my son or not my daughter. Well, you lose that control in a guardianship because A, you won't have the capacity to tell anyone who you want to be your guardian. And B, the order of priority in New Jersey is what's most likely going to be followed by the court and the judge hearing the guardianship matter. So one of the most important aspects of a power of attorney is having multiple decision makers and successors. That way you'll never run out of people and result in an expensive guardianship where the people you want to make decisions for you are not the people who may end up making decisions for you. Let's go to the next slide. So what are the common detailed drafting errors in financial powers of attorney? And today we're going to talk about financial powers of attorney, and we're going to talk about medical or healthcare powers of attorney. Number one is a gift giving provision. Why is this so important? If you are doing estate planning for the benefit of your children or your disabled child, and you're incapacitated, and the person you name as your decision maker doesn't have the right to make a gift or to establish a trust and make a gift to that trust, you can't use the power of attorney to do that. And once again, if we want to do estate planning for someone, for instance, establishing a trust for their disabled child and putting the money in the trust while they're alive, then their power of attorney doesn't allow their agent to make that gift, which is a gift, and establish that trust. We have to go to court. We have to have a guardian appointed, and we already know why we don't want to do that. More specific is a provision allowing the trustee, excuse me, the agent in the power of attorney to establish a trust. Uh, in New Jersey, powers of attorney are what's known as strictly construed, and we're going to talk about this in a little bit more depth. But the way this works is if there isn't a power in the power of attorney, it's treated as if the principal didn't want to give it. So we want to make sure that we can do follow-up planning for our developmentally disabled child, including establishing a special needs trust or an ABLE account. In New Jersey, we have special language regarding banks. Now, why do we have special language regarding banks? Banks don't like accepting powers of attorney. They're worried they're going to expose themselves to liability if the agent does something he or she isn't allowed to do. So they don't like accepting powers of attorney. So we have a law, and the law in New Jersey literally says if this law is included in the power of attorney, then a bank cannot turn it down. And you'll know you'll have the law because when you look through your power of attorney, you'll see the banking paragraph and it'll make reference to a statute. I'm not going to read off the whole statute, but it'll say NJAC or NJS. New Jersey annotated statutes or New Jersey statutes. If you see a reference to that with a whole bunch of numbers and colons, then you know you have that banking decision. Finally, powers of attorney don't get stale. They don't get too old, except the banking provision. A bank does not have to accept a power of attorney that's over 10 years old. Let's change. Next slide, please. So we already talked about this strict construction. What does it really mean? It means that because this power of attorney is so important, because it handles the most important things on our lives, there's what's known as a presumption in the law. And we all know about one or two presumptions, the presumption of innocence in a criminal case. The presumption in a power of attorney is that if you didn't give a power, you didn't want to give the power. And that's why powers of attorney have to be long, have to be detailed, have to be annoyingly detailed. Our powers of attorney are 14 pages long, our financial power of attorney. Our healthcare power of attorney, I believe, is 11 pages long. If you have a power of attorney and you go and you look at the form and it has one paragraph that says something like this: I give my agent the right to do anything I can do for myself. And by the way, I made that for a layperson, not the way it'd be written in the power of attorney. Then you basically have a useless power of attorney. Why? Because it doesn't specify the powers. It doesn't say I give you the right to do real estate transactions. It doesn't say I give you the right to make gifts, to attain my custom standard of living, to manipulate my mail, my insurance policies, my annuities. That's the type of detail that we're talking about. And it's really annoying in New Jersey. Some of you may have moved from another state like New York. In New York, every power of attorney is exactly the same. There's a law and it says this is what a power of attorney has to look like. In New Jersey, we don't have that. So we had to put all those different powers in this one document, and it's annoyingly long. If you have a power of attorney that's one page long, I guarantee it is not sufficient. You really need detailed powers. And why? We don't want to leave any holes. We don't want any gaps in the ability of your agent to make decisions for you. Let's go to the next slide. So, as I said, there's two general types of powers of attorney. There's a healthcare power of attorney and a financial power of attorney. When you look at a healthcare power of attorney, sometimes there is a big hole in it. A healthcare power of attorney should have two parts. One part covers if you're incapacitated and you're not dying. That happens a lot. It happens to a lot of people. It happened to me. It's easy enough to happen. And if you're incapacitated and not dying, you still need someone to make medical decisions for you. Now, a lot of people think I'm married, my wife can do that, or my husband can do that. Being married alone does not give you the right to make medical decisions for your husband or wife. Um, as a practical matter, though, if I'm in the hospital and I'm incapacitated and my spouse was there, yeah, they're going to listen to her until she tells them to do something they don't want to hear. And typically this occurs at discharge. I'm very sick. I have fevers. There's my monitors on things. And somebody walks in the room and says to my wife, "Oh, Harold's fine. He can go home." And everything intuitively says, "Yeah, Harold doesn't seem fine. It doesn't seem like he should go home." So my wife says, "No, I don't think Harold should be discharged." And then the hospital says, "Well, do you have healthcare power of attorney?" And she says, "Yes, I do. I have this." And they look at it and they say, "Oh, no, your husband's not dying. You don't even have a healthcare privacy consent in here. We can make any decision we want about him. So we're sending him home, or we're sending him to a nursing home that you don't want him to go to." So, in your healthcare power of attorney, you want to have those two parts. The first is the end of life, or the ongoing medical decision document where you appoint a healthcare proxy. And the second is the end of life document that is often called a living will. When you go home and read your document, it may be ambiguous, which is good. Why? Because these powers of attorney are not as strictly construed as a financial power of attorney. So if you have a paragraph in there that says, "I appoint John Doe as my healthcare proxy," and it doesn't limit it to end of life decisions, then you're probably okay. If you know you only have a living will, most likely there's a hole there. The hole is in the ability for someone to help you or advocate for you if you're in a hospital, and you really need that second document, that healthcare power of attorney. Let's change next slide. Um, so what are the major errors in the healthcare power of attorney? Number one, and this is just redundant, no end of life provision. No HIPAA consent, healthcare privacy law consent. And by the way, that's really important, especially with health insurance companies. Your child is over 18, he or she are covered on your employment policy. You call them up and say, "My developmentally disabled child, has a question." They're not going to talk to you. Okay. Maybe if you're their guardian, they'll talk to you. But if you just have a power of attorney that does not have a HIPAA consent, they will not talk to you. No one will talk to you. No successor agent. We talked about that. It's really important to have multiple levels of agent. And here's one of the more important ones, especially on the end of life. These end of life decisions are hard. I was sitting with someone 35 minutes ago, and we were talking about his father and end of life decisions. And, um, uh, you know, this gentleman and his siblings all felt the same way about life and quality of life and things like that. He was the sole decision maker in the power of attorney. But if he had another person who was his co-agent, co-decision maker, who felt very differently about end of life issues, and by the way, people feel on a very broad span about end of life issues. It isn't just the people who want, to stay alive forever. It's also the people who would cut you off maybe a little prematurely. You want to make sure that people you name as agents know how you feel about these things. And they're very hard decisions. Now, I'm going to deviate from this just slightly at this point. One of the powers of attorney I mentioned on here, which is probably the subject of an entirely new Lunch and Learn, is a psychiatric advance directive. We now have a document that is established under New Jersey law that allows a person to say what care they want voluntarily or involuntarily under a psychiatric advance directive. So let's say, for instance, I have a very difficult bipolar episode, and um, I want to make sure that my parents or whoever that decision maker is can, in essence, get me the care that I need. And because I'm bipolar and I'm having this bad moment in my life, I'm going to fight it. I'm going to say, no, I don't want to go to an inpatient care, or I don't want to take this medication. We now have a psychiatric advance directive. So when I'm on my meds and I'm doing fine, I can just tell the world that, yeah, I want somebody to be able to involuntarily commit me. I want someone to be able to require me to take my medication. And this is an incredibly important tool that we have now, that it's rarely used because it's very difficult, but it's something I want to make everyone listening aware of. And I'm more than happy to, um, give people copies of this form. All you got to do is put your name in the chat. Let's go to the next slide. Let's talk about wills. Now, what's a will? A lot of people think they know what it is, but let me be didactic. A will is a document that names someone, an executor, to manipulate your assets in your name alone with no joint owner or beneficiary after your death. So for instance, I have a bank account at TD Bank. It's my name alone. I die. No one in the world can close that account and give the money to my heirs in my will. And the only person who can do that is my executor. To become an executor, you have to probate. You have to go to the surrogate court and give them paperwork, and then you're named executor. And you get an official piece of paper that says you're the executor. And then when I'm my executor, I have an executor in place, that person can manipulate my assets, follow the terms of my will. So, what are some errors people make in wills? Failing to take into consideration the specific and special characteristics of your heirs, disabled heirs, minor heirs, spendthrift, and heirs with drug or alcohol dependency, and divorce. So, people often make their wills when their children are just born, and then over time, they neglect to change them based on changing circumstances. We in a will can take care of all these issues. We can set up a third-party trust for a disabled heir. We can, which we're going to talk about in depth a little later. We can set a trust in a will for minors so they don't get their money when they're 18. We can set aside money for an heir that you know just can't hold on to money, or an heir that has drug and alcohol problems. And we can also protect against our children who may get divorced down the line, and protect your legacy you're leaving that children from that divorce. And this is all possible in a will. And it's easy. It's not hard. It's not time consuming. And it's something that you really have to take in consideration of. Let's jump back a generation. Your parents. Most people's parents are leaving their assets to their children. And one thing you don't think about when you're the grandparent of a disabled person is the fact that that disabled grandchild may come into money, but they can. I have two sons. If I died before my mother, under the terms of her will, my sons get my share. Now, neither of my sons have any of these problems. They're single, they're not disabled, they're not spendthrifts, and they're not minors. So I don't have to worry about this in the case of my mother. But if one of my children was disabled, I would want my mother to leave that child's share to a third-party special needs trust. And it would be a hard conversation to have with my mother. I'd have to say to my mother, Ma, if I die before you, you can't let Sam get his money directly because all those benefits we talked about in the first slide are going to go away. And we're going to have to do something we really don't want to do. So this is a hard conversation to have with your parents, but it's an important one. And I'm gonna hit upon it again when we talk about third-party special needs trust and first-party special needs trust. Running out of heirs. Running out of heirs is very similar to running out of agents. Remember where I was talking about that in the power of attorney? How your guardian may end up being someone you didn't want to be your guardian? Well, the law has that same order of priority. And I get this question all the time. And usually it's from single people. They say to me, all right, I want to leave my money to my brother and then my friend Joe. And I say to them, well, what happens if your brother and your friend Joe die before you? Do you know who another person? And they go, I don't know. And I say, well, let me tell you what would happen. I say, you got any brothers and sisters? Oh, yeah, they're okay. I don't talk to them much, but they're okay. What about your nieces and nephews? Oh, God, they're terrible. They never call me. They never send me a Christmas card. Two are in jail. Okay. And I tell them, well, look, if you run out of heirs in your will, this is what happens. It's called intestacy. Intestacy means that the law says who gets your assets. And generally, intestacy starts with you. And if your heirs below you, then the people you name in the will are deceased, the money, your assets go up to your parents. Now, most of the time, your parents are gone. Then it goes over to your siblings. That's great. Sometimes people are very happy the money goes to their siblings. If one of your sibling is dead, their share goes to their children, nieces and nephews. This is when people start to get a little uptight because they don't have a good relationship with their nieces and nephews. So it's always important to think these things through. And I drive my clients crazy because I want them to understand this and I want to do a good and thorough job. And I always say that I can do a bad job very quickly. But to do a good job, it takes some time and it takes some patience. And in the long run, if you know what the outcome is going to be, if you run out of heirs and that's acceptable to you, that's fine. Okay. But I just want to make sure that people know. And the last one is running out of fiduciaries. Fiduciaries are executors and trustees. And we want to make sure that we always have enough people in to act as executor and trustees for the very same reasons that we want to have enough agents and enough heirs. Because once again, the law determines who would be your executor and your trustee. And an executor can take a fee, and a trustee can take a fee. And the fee could be high. In an estate, the fee is 5% on the first $200,000, 3.5% from 200,000 to 400,000. And I think it's 2% above that. I never memorized that third one, but it's a lot of money in a big estate. And someone who you don't want to be your executor may end up being your executor just because they wanted the fee. Let's move to the next slide. Okay. Common special needs trust errors. Now we get into special needs trust. Now, a lot of you probably have had some minimal contact with special needs trust, but let's start at the beginning. Two types of special needs trust. Third-party trust, first-party trust. What's a third-party trust? A third-party trust is a trust that we set up for someone else with our money. So I have a child with developmental disabilities. I set up a third-party special needs trust. Why? Because when I die, I want my child's share of my estate not to count against him or her for that eligibility for Medicaid, SSI, and DDD. The first slide. There are huge benefits to a third-party special needs trust. The major benefit is the money in the trust doesn't count toward the $2,000 limit. My child keeps his or her benefits. But here's the big benefit. At the end, and I talk about this again in another slide, at the end, when my child dies, that money in that trust does not go to the state of New Jersey. It does not go to the federal government. It goes to my other children or their children. So I can set up a trust for my child with developmental disabilities. They can keep their benefits, and at their death, the money stays in my family. Then we have a first party trust. What's a first party trust? I'll give you a good example. My mom leaves $20,000 to my developmentally disabled child. She doesn't leave it to his trust that I established. She leaves it to him because her lawyer never asked the question, do any of your grandchildren have disabilities? So now my mom dies, my son gets $20,000. I got to do something with it. I got to do something to keep his eligibility for benefits. What are my choices? Well, I gave a bad example. One choice is to set up an ABLE account. I can put only $18,000 in there, and I got $2,000 left. Yeah, and I could spend that money on my kid. I could buy him clothes. I could do some stuff for my kid. What if it was $50,000 or $60,000? My only choice is to set up a first party special needs trust. And what's the problem with that trust? Number one, highly regulated by the state of New Jersey and the Social Security Administration. I had to file annual accounting showing them what I did with the money in the trust. Number two, at my child's death, that money in that trust doesn't go to my other children or my grandchildren or their heirs. It goes to the state of New Jersey. So a lot of what we're talking about ties together. I always say this discussion is like a bad comedy routine because something we talk at the beginning ties into something at the end, but it's never funny. So we talked at the beginning about the benefits of a third-party special needs trust. Well, now we know the downside of not having it. The downside of not having it is money left to your child, not expended out of the trust at the time of their death, goes to the state of New Jersey. So yeah, we get those benefits, but in the long run, the outcome isn't the optimal outcome. If we had a third-party trust, it would be. Let's go to the next slide. Common drafting errors in a third-party trust. The biggest error is not having it. Why? People have misunderstandings about this trust. People think that the money in the trust will interfere with the eligibility of their loved one for benefits, and it just isn't true. It's absolutely not true. A third-party trust is a vehicle that protects your assets, allows them to be used for your developmentally disabled child, and then at their death, the money goes to the state of New Jersey. And by the way, since it does not go to state of New Jersey, there's been some liberalization under the Social Security law about the use of these third-party special needs trusts. As of September, the limitation on not being able to use them for food has been eliminated, which means the trust can now be used for food. If you use a third-party special needs trust in conjunction with an ABLE account, the money in the ABLE account can be used for shelter. So realistically, the only limitation right now on a third-party special needs trust is clothing. The money cannot be used for clothing. So anyone who wants to leave assets aside for a person with developmental disabilities, and that can be yourself, your parents, your siblings, maybe they don't have children and want to leave some money to your sibling, and I do that all the time, can establish a third-party special needs trust or modify their will to leave that bequest to the third-party special needs trust you established for your own child. Let's go to the next slide. Common errors in first-party trusts. One thing that's great about a third-party trust is it is highly amendable. You can amend it at any time to make it comply with the law. A first-party trust is amendable too, and there are in New Jersey 27 different state requirements, not federal requirements, state requirements for a compliant third-party special needs, first-party special needs trust. And, unless you're the type of lawyer who does this work, goes to the regulation in New Jersey and has a good checklist as to making sure all the provisions are in there, there's a very good chance that the provision isn't in there. And what happens? Well, it depends on the terms of the trust. Some trusts say that the trustee can amend the trust. Some trusts say only the grantor can amend the trust. And if the grantor is incapacitated, remember, this is a first-party trust. I set it up for myself. I have a guardian. I have to go to court to have the trust amended. And that costs a lot of money. So it's very important that if you go to any lawyer, and I'm not assuming you're going to go to us or Pauls and Reckham, that you make sure that your first party trust has these 27 elements in it. Where do we run into some problems with first party trusts? That's people moving from one state to another. The state of New Jersey is draconian in its rules with regard to Medicaid and first party trusts. And most likely, a first party trust established in another state will not comply with New Jersey law, and we have to amend it if it's amendable. Third party trusts are highly amended. And I've had plenty of clients move in New Jersey from other states that didn't need to change a word on their third party trust. But the first party trusts are very specific in New Jersey. To a certain extent, I'm sure there's very good arguments that New Jersey's violating federal law and pretty much getting away with it on its very specific and draconian requirements of first-party special needs trust. But the bottom line is that they have to have these 27 conditions in them, and if they're not in there, the trust will be determined non-compliant, and we'll either have to amend it or literally establish another trust. I think, is that the last slide, Karina? Yes, it is. So, wow, I did this in 12 minutes. It's 12:50. That's pretty good. I don't have a lot of questions in the chat, so I'm very happy. If you want to add a question now, do so. I am gonna, there is one question in here. Do we need to go back to court to add successor guardians for our guardians for after parents pass? How is that done? That's an excellent question. So, yeah, the answer is yes. If both guardians die, then someone has to file in court to have new guardians appointed. It isn't the same level of detail and sophistication as the first guardianship proceeding because the determination of incapacity has already been made. It's merely a procedure to have someone appointed. Now, unfortunately, it's the same procedure, though. You file a complaint, a court-appointed attorney is appointed. The attorney then looks at the priority of who can be a guardian in New Jersey and makes a recommendation to the court. Now, one important aspect of this is in your wills. In your wills, you can say who you would like to be the guardian for your disabled child. It isn't a mandatory provision, which means the court-appointed attorney doesn't have to follow what you wrote in your will, but he or she probably will because that was, your intention and it's something you thought out. And most likely they wouldn't deviate from that. But in New Jersey, we do have this order of priority. What's best, trust or will, and heir versus fiduciary? I'm not a big believer in when this question, I could answer this question a million ways over an hour. I believe a third-party trust should be outside the will. In New Jersey, I really don't believe in living trust. What's a living trust? A living trust is a trust that you put all your assets in, and then you avoid probate, and it saves some time. I'm not a big believer in doing that because it's expensive. And it doesn't change the tax outcome if there are tax issues. But the most important reason is most people can't get all of their assets in a living trust. So for instance, I have an IRA. I can't put my IRA in a living trust. It has a beneficiary, so that has the same outcome. I have a bank account. I don't put that in my living trust. A lot of times people don't want to put assets that have liabilities in the same trust with an asset that doesn't have a liability. So for instance, I rent out a property or I have a car. I don't want that in my living trust. Why? Because if there's a huge loss and the insurance policy doesn't cover, the other assets in that trust are on the table for paying that liability. I don't like doing that. So I like a standalone third-party trust outside the will. The next question is an heir or for diverse fiduciary. I think that question is, in essence, and the person who posted it can clarify if they want. Do I want a human being to be my trustee? Or do I want a trust company, an entity to be my trustee? I like human beings. Why? Because most people have a relationship with your child. And, whether it's because they're related, because they've known them for a long time, I like human beings rather than institutions. Institutions can be kind of cold and they can also have their own agenda. So for instance, I'm a big trust company. I'm managing a $2 million trust. It's a special needs trust, which has very complicated distribution terms. Well, it's easy for me to say, I'm going to hold on to this money and make my profit off of it rather than distributing it. Some people don't have human beings, and there are some good entities. If you live in Bergen County, the Bergen Passaic Arc has their own standalone trust entity. We have Plan New Jersey, which has kind of cornered the market as trustees of trust, of special needs trust. I'm not a big fan of that just because Plan New Jersey doesn't allow a human co-trustee. They allow a trust protector. A trust protector can fire the trustee and hire a new one, but they don't allow a human co-trustee. This issue of who's going to be the trustee of your special needs trust is the most difficult issue my clients have, because we're talking about projecting into the future 30, 40, 50 years, our children, when we're definitely going to be gone and we want someone to manage our children's lives. And I used to really struggle with this decision. And now I kind of have a solution that's workable. And here's a solution. You name human beings. You give them the right to name other human beings if you want, or entities. And that way, so long as the people you name understand the goal and are competent enough to know that they don't know everything, because no one knows everything about a special needs trust, I promise you, then that person you can rely on to appoint someone in the future, because we definitely want someone around for your children's lives. I got 3 more minutes. Any more questions? Okay, great. So if you do have a question you didn't want to ask, you can send it to info@Parles&Reckham. I'm going to put my direct email address in the chat. But I promise you, if you send something to Parles&Reckham, they will send it to me. You're welcome very much, the person who just thanked me. Here you go. Boy, I'm getting a lot of thanks here. That's great. Thank you very much. And if you do have questions, you know, you can tell I am didactic. I am a big blowhard. I'm happy to answer your questions. I think the most important thing is to have clarity on these issues. Um, and if there aren't any other questions, Karina, I think we're done. So I thank you very much. I hope you all have a good week. You know, stay warm and dry. And I'm looking forward to working with anyone who wants to work with us at Parles and Reckham.
Thank you, everyone.